Okay, so good afternoon, everybody. This is our Monday seminar at the Amsterdam Center for Transformative Private Law. And today we have a guest from far away, at least, well, in the ways that that hospitality works these days. So Dr. Kingsley joined us from what could be his living room or office. But we are very happy to have him here. I will say a couple of words because I think the profile of the speaker really deserves a bit of a devoted introduction. So Dr. Kingsley is a senior lecturer at Swinburne Law School in Australia. And there he is busy with well, some large research projects and also very actively involved in education. I shared a tiny project of mine with him and immediately received 8 different attachments that I could use as reference for that purpose. But the reason why we have invited him here today is for him to discuss his project on Inter-Asian Legalities, where he has been working on the ethos and behaviors of transnational lawyers, in particular in Jakarta, but not only in Jakarta. I read that Dubai and Singapore are your other legal hub case studies. And we came across this article via private law theory blog, so in case good to give advertisement to the blog, and the piece. Well, what struck me about the idea behind the piece is that you moved from investigating religious and political leaders to looking at lawyers in your anthropology. So I'm very curious how that move appeared, and well, you concentrate on corporate lawyers, so this is, of course, also something that is of particular appeal to our center. And basically, I think, what I can out now is just a lot of curiosity, and I shouldn't take more space from you. Jeremy will speak for 30 to 45 minutes, and afterwards we will have space for questions. So thank you, Jeremy, for being here with us today. The floor is yours.
Oh, wonderful. Thank you all. It's a good afternoon for you, or salamat sore, good evening for me, salamat malam. I wanted to, and I hope this is okay, but because I am sitting in Australia, I'd like to do a acknowledgement of country, which is, I would like to acknowledge the traditional owners of these lands where I sit today, the Bunurong people, past, present, and emerging, and recognise their continuous connection to the land, water, and culture on the surfaces on which I learn, live, and play. And so that's quite normative in Australia to realise that we are a settler population, and I just think that's worth recognising at the start. I want to thank Candida for inviting me today, for Lindsay for assisting with getting this together. And as was noted, this really comes out of an article, one of a string of articles that I've been writing that has emerged out of my research in, primarily actually in Jakarta, but also with sort of bolt-ons to other legal hubs, obviously Dubai and Singapore. And it really comes out of me having lived in Singapore and worked at the National University of Singapore, at the Asia Research Institute and the Middle East Institute. And those two entities were the inspiration for what I'm really about to talk about today. And it's interesting because you asked, how did I start start working on lawyers, transnational lawyers, from looking at alim or religious leaders in Indonesia on a tiny Eastern Indonesian island, right to the east of the archipelago, or at least the gateway to the east of the archipelago. And that will actually, it's not a bad place to start. So I'm going to sort of subvert my entry point just to explain the connection, because the connection is actually very logical and helps to explain my interest in transnational corporate lawyers, and also sort of where that emerges from. I've always been interested in this idea of legal intermediaries, people who mediate law. And when I say law, I mean that in a broad sense, not in a limited state-centric sense. And the reason that that is important is because the law I look at mostly is either below the state or above the state. Okay, and I don't mean as in sort of a hierarchy of laws, but as in the sort of nature of the beast, in that the religious leaders that I looked at in Eastern Indonesia were intricately involved in implementing local governance, local law and rulemaking. And their choice of armory, their choice of tools was Islam. Now, for scholars who don't know Southeast Asia that well, they may not know exactly about a click in automatically the resonance of that. But by way of a little bit of background, if you want to understand mercantile law in the Indian Ocean, from the Gulf, Aden in the past, Yemen in the past, or now Dubai, sort of Eastern Africa, through India, South Asia, South Asia, let's say, downwards into Southeast Asia, you have, and even actually up into East Asia and across the inland roads, you have to recognize the role of Islam, not as a faith per se. I mean, it is a faith, obviously, but as a mode of legal instrument, i.e., the Hadrami who came to Indonesia and brought Islam to Indonesia came alongside traders, and their role was to make contractual relationships across the region. So if you look at the early trading documents from Malacca across Indonesia, you will see, and early Singapore, you'll see the role of Islam. And even today, when you look at Indonesia's economics and the way that it works politically, you cannot pull out of that equation the role of faith. And I don't mean the role of faith simply as I grew up with it in the sort of West, which is as a private practice, but faith as a public indicator, a mode of legitimation and authority. And so the importance of of having learned scholars sign off on your contracts is very much the same idea that John Flood talks about when he talks about sanctifiers being transnational corporate lawyers, i.e., you go to Clifford Chance not just because you get a good lawyer that comes out of Clifford Chance, or Allen and Overy, or White and Case, or in Southeast Asia, Raja and Tan. But rather, what you get is someone who has a private so the parties accept and acknowledge a certain currency to who they are. That it's acknowledged in the background. And like John Flood said, they sanctify in many ways the contracts. So in many ways, what we're talking about when I was looking at the alim, or the religious scholars of Eastern Indonesia, was exactly the same idea as what I was looking at when I go to Jakarta and sit in a corporate law firm, or I go to Dubai to meet an international arbitration expert, i.e., what we're talking about are people who have an authority and legitimacy brought by, obviously, their admission to practice. That's one thing. But admission to practice is like in Islam, the ijazah. The ijazah is, your base certificate. But more than your base certificate, it is your lineage of who you come from. So what we're talking about is prestige, pedigree, etc., which builds up from that base acceptance. So that's sort of, I know that this is a strange connection. Everyone finds it really odd, but if you look at legal intermediaries as the people who allow and facilitate private legal arrangements, then you're looking at the same thing. It's just a different historical moment and a different cultural background. So that's the background to it. And so when I'm going to share my screen with you also. Okay. It's not really much of a slideshow, to be honest about it. Okay, so I wanted to go through this presentation and ask you to bear in mind 4 questions. The first is, how do we understand interconnected legal realities? And that's the sort of whole idea that we're creating an architecture across Inter-Asia. And how do we understand a complex fabric of governance? And when I talk about complex fabric of governance, I'm really talking about ideas and concepts around a new form of lex mercatoria emerging in Asia. And then the third question is really what I've just been talking about, but who facilitates the complex interconnections? Who are the legal intermediaries? And in this case, my argument is that really what we're talking about now in Southeast Asia are these transnational corporate lawyers. And finally, the fourth question is more a provocation than really that comes out of this article, but why don't we actually discuss this complexity in law school? Why do we in law school continue to live with a mirage that there is domestic law and international law? And then sometimes we get a bit tutti frutti and we'll add in some transnational law to give color. But in most law schools at the moment, a legal education is really domestic, a little bit of spice added by international, and then some more spice if you want to get it sort of a bit colorful and add some transnational on it. But why are we minimizing the scope of law? And in Southeast Asia, when you look at and Australia, to be honest, and I'd say many parts of the world, we have to look below the state. So one of the greatest sins, and when I gave the welcome to country in Australia, legal history is this idea of terra nullius, or a country without inhabitants, void, empty. And that was, and I was going to say a colorful language, but it was, I think I'll just leave it, the nice vocabulary, but that is a lie. That it's a legal lie. And it took us almost 200 years of white colonization to acknowledge that legal lie. So what I'm saying is that that legal lie is about what lies below the state, i.e. that Indigenous communities in Australia have a legal system and structure that existed and still exists. And in Indonesia, when you're looking at legal ordering, and I think a colleague of mine from Jakarta is in the thing, you need to, even in complex corporate arrangements, you'll see that adat law or local customary practices are essential to understanding the legal landscape. And sometimes people think that that's on maybe in Australia native title issues, or in Indonesia maybe forestry issues. But let me explain to you how serious and how complicated and how important understanding local authority is. So when we talk about in Indonesia about adult or local customary law, social process, whatever you call it, traditional law, it is not to be trifled with. And what I mean by that is that everyone knows that there's, what's that fashion, the luxury brand, Bulgari, there's the Bulgari luxury brand, and they do jewelry and sort of all higher end products. They have a hotel in southern Bali. And they entered into a period in which, after they had an arrangement with the local community in which they would have a certain number of people from the local community working in the resort, at different levels, some in the cleaning department, some in the kitchen, some in the, security, etc., and so that there would be, in some ways, so that the resort would benefit the local community. And over time, and it was sort of written down that, there was, 3 people in security that were meant to be from there, 2 in the housekeeping, whatever it was. And it was documented. And so over time, that sort of started to fall apart, fray. A few people got sacked and other people weren't changed, and, some retired and weren't replaced. And eventually the local community said, like, hey, where are we? This arrangement's gone. And the management said, tough, we're working, we don't really need you. Well, that was, and they didn't use those exact words. They were maybe a little bit more diplomatic than that, but not much. And eventually they were, their hotel was blocked for several days. The roads in and out were cut by the local community. And their lawyers had to negotiate the reopening and renegotiation of that sort of labor arrangement. So the way that local communities engage and are involved in very real, tangible economic and commercial activities in Indonesia can't be underestimated. You can't get a hotel organized in Bali unless you have the approval of the local community. It doesn't happen. In mining contracts in Indonesia, there are, and this is somewhat problematic in itself, but it's we can discuss that a bit more. But in mining contracts, you have to include local communities. So these are local ideas of law, social process, leadership at the local level is incredibly important to that understanding of the sort of legal architecture. That's below the state. My work in Eastern Indonesia with local religious leaders was below the state. But you couldn't work in Lombok without having the approval of the religious leadership. It just didn't happen. And the religious leaders were heavily involved in economic and commercial life because of their role generally as social and organizations. So what I'm trying to get at is that when we're articulating these models of lawmaking, we have to look below. Then when we're articulating this law, and this goes into the sort of why aren't we teaching this at law school? And this is even more standard, is how do we deal with all these private legal arrangements or contract-based, which weave their way within and without the state in relation to contract law, that basically allow businesses, investment in the form of capital, and people in the form of either executives or workers to flow across borders seamlessly, often. And this comes at a time, and it sort of felt very odd and awkward for me to write about this at a time in which somehow transnational law was still working, but we weren't actually moving as much, or at least Australia, Fortress Australia didn't seem to be moving that much. But still, that transnational element of law, that privatized legal arena, is pivotal to understanding, I believe, this sort of a newly forming legal architecture. And one of the things, though, that I want to be sort of clear as a caveat to this discussion is that even though I talk a lot about private ordering, either sort of above or below the state, one can't ignore the state in any of this ordering. The state doesn't disappear. Like in some anthropological work, it's sort of like we want to sort of ignore the state. But in complex legal transactions, a good example, let's look at a good example. You can have a whole series of really complex privatized contractual arrangements, but you still have real property in a place. There is still a factory built on land outside Bandung. It doesn't matter that you have an incredibly complicated private relationship in which arbitration is going to be in Singapore and 80% of the commercial arrangement is in Singapore, 20% in Indonesia, but there's still land there. There's still a security. In common law, there's still a lien, although Indonesia is not a common law jurisdiction, there would still be a lien on that property for security purposes over the land. Right now, obviously the way that's drafted in a civil law jurisdiction is slightly more complicated, but that's still, that basic presumption still exists. So there's still a deep meshing between commercial and this level of lawmaking. Now, I talk about it, rather than talking about it as a hierarchy, I'd like us to think about it as a fabric of governance. And I talk about that even in my early work on religious leaders, that rather than, and this sort of comes out of it, it's funny, out of a halachic idea, so a Jewish idea. And when you actually look at it, it's quite a nice, it's one of those sort of canonic texts in the Jewish tradition called the Shulchan Aruch. And that text is, it talks about a tablecloth, law being a tablecloth. And I want us to think about law, no, I don't know if it's totally halal to think of it in coming from halal, but to think of law as a tablecloth, a woven tablecloth, in that all of these different strands of law, of legality, operate to provide and to facilitate this quite complicated arena of lex mercatoria, or a reimagining of lex mercatoria. So I'm not going to get into the argument of does lex mercatoria, did it exist or didn't it exist? That's for minds greater than my own and historians greater than my own. But what I'm interested in is a reimagining of lex mercatoria, a reimagining of a law according to merchants, law which works its way within and without the state. But to do that, and this goes really, we're sort of circling back once again to transnational corporate lawyers. And when I talk about transnational corporate lawyers in this article, the definition I give is both the front end transactional lawyers, what would be considered people in corporate or M&A groups, merger and acquisition sort of teams, or those in dispute resolution. And in that term, when we talk about dispute resolution in this arena, I'm primarily talking about people involved in international commercial arbitration. Although, obviously, like I said, if you're doing a commercial transaction in Indonesia and real property is involved, then obviously the Indonesian courts, for instance, will be intricate to that process too. But really, largely what I'm talking about is the way that lawyers, these transnational corporate lawyers, have carved away a privatized dispute resolution framework. And what I was interested in emerges out of like a whole lot of discussions in bars with corporate lawyers in Singapore. And it came out of a discussion in which we would talk about what law do you apply? There are these Australian lawyers, so they're friends of mine from law school, and I was at the university and they were in corporate law. And so I'm saying, like, so you're admitted to practice in Australia. Some of them were admitted, had been also admitted to practice in London and Paris, but they were in Singapore now. And I said, so are you're practicing Singaporean law? Do you ever go to, do you have right to go to a court in Singapore? And they said, no, of course we don't. And they'd say, and so I'd say, what's your practice? What are you doing? Like you're obviously making a lot of money. Sorry for being crass about it, but that's what what drove me. You're making a lot of money. What are you doing to earn that money? Who pays you all this money? And really, what we sort of, people would start talking to me in really weird terms, like best, international best practice. This was the law. I said, at law school, I've never heard about international best practice. No one talked to me about this idea. I'm like, what is it? What are you doing? I said, and okay, two of my friends were doing international commercial arbitration. So I realized, okay, there are arbitral clauses in the thing. Okay, that's how you got jurisdiction. That's why in Singapore, SIAC, you sometimes fly to Hong Kong, sometimes fly to Dubai. But I kind of understood what they were doing. Then there were people doing insolvency law. There were people doing corporate law. I was like, so really, what law are you doing? And then they would start to talk to me about the fact that they were really working in this transnational law. But I know that for a lot of you that may seem sort of naive and it should be obvious that there's transnational law. But what interested me was the sort of architecture that their existences were bringing about. What were they doing? How did they work in the world? And that's really where we come down to these sort of key terms. And these are the sort of ideas that I sort of want to bed into the sort of discussion, which is this idea of inter-Asian legalities. And I use the word legalities rather than law because I'm wanting to be clear that this is not always strictly state law. And like I said, if it's privatized law, how do you that is by implication a moving outside of sovereign domain. And what does that mean? And if we're talking about my experiences in Indonesia, what do my experiences of ideas of importance of adat, etc., how does that fit into this equation? So I wanted us to have a definition of law or rulemaking which was broad enough to take into account a new architecture. And really, in some ways, what I'm talking about when I talk about inter-Asian legalities is the mechanics of globalization in my corner of the world. Okay, that's what I'm talking about. I want to understand how globalization works in my neighborhood. And my neighborhood is Australia and Southeast Asia, and then sort of outwards from there. I wanted to talk about Lex Mercatoria. Obviously, most of you will know that's the law of traders. But what was interesting for me was a reimagining of Lex Mercatoria, of actually starting to think through this idea of Lex Mercatoria, not as this sort of romantic idea of something that happened in Venetian times and that we learn from Merchant of Venice, but really something that lives today, that comes out of ports such as, ports and trading cities such as Hong Kong, Singapore, Dubai, Rotterdam, etc. i.e. where there's a fluidity of movement, where goods and services come and go. I mean, my office in Singapore at the university overlooked the port. And that was for me when I sort of realized law has to be something, we have to reimagine law to understand law as a flow. Not just as, because I learned in law school, law as borders. What's Australian domestic law? And even more than, what's the state of Victoria, which is where I sit at the moment, what's that law? And it's important. I should know, Victorian law. I teach Commonwealth of Australia and State of Victorian law in class. But that's not adequate to reimagine the way that globalization works and the sorts of pressures it puts on ideas of law. And and in many ways, my sort of looking out over the port came at the same time as I started to intellectually dance with people in SDS, or science and technology studies, and started to think about things that were blurring in relation to the role of the digital. And in some ways, for me, it kind of was a cheat sheet to explaining the complexity of this architecture. And the way I look at it is, I always give this analogy. I am buying a record, a vinyl record. I'm going to be really hip and buy a vinyl record. And I buy it from a company based in Singapore. But the payment system is coming out of Malaysia. So I'm sitting in Melbourne. I'm buying a vinyl record in Singapore. The payment system is coming out of Kuala Lumpur. And the server farm that is facilitating this whole transaction is in Thailand. Where's the jurisdiction? How do we work out the jurisdiction? There's at least 3 or 4 contracts involved in that very simple $20 transaction, €10 transaction. Where is it the sale? The sale arrangement will only go to half of the transaction, if that. What about the finances? What about if my money gets lost on the way via the platform and in KL, etc., etc. And what interested me was to try and work out, okay, we're living in a world in which we can see the physical and digital infrastructures exponentially changing things. We can see that law doesn't seem as simple as we have, it's not a simple in and out situation. It's not bound, a commercial transaction is not bound by Victorian borders or, the Netherlands. It just isn't. In the European Union, there are questions as to what's the role of the European Union in the place of, Dutch law. How does it integrate, right? Now that you've got the UK, et cetera, et cetera. So we live in a world in which our boundaries are so fuzzy and blurry, but that allows us a space and a time to start reimagining things. And our reimagination is, I sort of places this idea of a new substantive law being lex mercatoria. I also want us to talk about transnational law, although I think that term is a little bit limited. It's only part of the discussion. And the focus of our discussion are the Jakarta's transnational corporate lawyers. And by way of a bit of background, all of this research comes out of about 5 years of research and several months in 3 major firms, or 2 major firms and a boutique firm. And I'm not going to go into the firms' names for ethics reasons, but that's the 2 top tier, and then one which is a top boutique tier firm. And my idea was, rather than learning about law as I like to imagine it, and I imagine things a lot, I've got a vivid imagination, but to really look and to think, okay, how do people work? Lawyers hate. It's one of the really most interesting things that if you try and look up ethnographies of lawyers doing the stuff they do most, i.e. sitting in their offices drafting contracts, it's almost impossible. I mean, you get some great ethnographies of courtrooms, Lawrence Rosen's stuff in Morocco. You have Pellitz's stuff coming, Michael Pellitz's stuff in Malaysia. Great stuff in courts, but that's spectacular. That's not really law. I mean, we like to think it's law, but I actually think most of the law happens in boring offices where you see lawyers poring over contracts or case, sort of evidence for a case. That's all silent. That's all unseen. But that's actually how often I think you get to know and understand what's really going on with the law. What really are the pressure points? I mean, Bruno Latour's work in the French Court of Appeal, when he sort of follows the life of a document, it's mundane, it's boring, but following this life of a document and the people's hands it goes through tells you not just about the people who handle the document, but actually what the law is. Because the law is always going to be a series of discretions, of choices. Do you use these sorts of documents? Do you use those sorts of documents? And the case study, and I'm going to fast forward a little bit because I said I wanted to sort of speak for about 45 minutes and then allow for questions. But in the case study that I go through, what I'm looking at is the most mundane, the most boring of legal jobs, i.e. giving a legal advice in relation to a contract. Okay, and so the case study I look at, it basically runs over 3 days. I am acting as a junior lawyer in this instance. We get 2 contracts, one which is a contract on foot and one which is a contract being proposed. And the contract which is on foot is fairly fair, fairly balanced, not a great contract, some significant flaws in it, i.e. it's only in English, and in Indonesia you need to have, there's big controversy over whether the document has to be also in Indonesian, if one of the parties is an Indonesian company, but that we can go. I mean, I've written just a recent article with Tim Lindsay and Nadia Hossan about this particular issue, but let's even forgo that problem in the contract itself. So what happens is a European, basically software / a digital platform that provides travel support. It's sort of like a database. It helps create and manage the database for hotels, all the sort of hotel packages and prices and airfare prices and packages. And it's a system that sort of helps a travel agency, which was our client, the Indonesian client, to manage a online portal for travel in Indonesia. And when we got the contract, we realized this was the most ridiculous concept. I mean, it just had, everything was wrong. It was so unfavorable as a lawyer on almost every level. It was unfavorable on levels that it didn't give, I mean, the first, basic one was our client didn't get exclusive rights to the Indonesian market for this particular product. And if you, as a porthole, if you want to have an advantage, this was their sort of advantage. And they gave up exclusive rights. In the initial contract, they have exclusive rights. In the second contract, they don't. And, as a lawyer, I'm like, oh, don't do that. Have some caveat, have some carve out, have some protection to your interest. It's not insignificant. It was $5 million a year over 5 years. It's not nothing. It's not huge, but it's not nothing. To having clauses there, which were to have an arbitral, the arbitral clause chose the ICC in Paris as the seat of arbitration. Now, for a contract this size, 25 million, that's putting it at its maximum. That's as if the whole contract from start to finish fell apart at one time, which it couldn't possibly. But so we're talking, it was such a ridiculous choice of arbitral forum. I mean, if you were going to be doing it, having arbitration is quite sensible for this arrangement, but pragmatically, you would have chosen Singapore or Dubai. Singapore being very easy for the Indonesians, and Dubai also. And I know that this sounds sort of odd, but pragmatically, for the size of the arrangement, the forum was just all out of shape. And then we pointed out all these issues, and we wrote the letter of memorandum. And then we went a few days later to the business, and we sort of said, my counterpart started listing all the problems. And then I started, and the business and the general managers started, it doesn't matter. Don't worry about it. Don't worry about it. And to everything, all my colleagues' points, or my points about the way that, sort of international issues would arise out of the drafting and the way it will work, and nothing, it didn't matter. And, it became quite a tense meeting because we didn't really, and the sort of partner that we were with had to intervene and sort of smooth over the tension, because we just hadn't realized what this business's commercial orientation was. And it basically was that the contract itself was important, but not for the particular terms. The contract was important as a symbolic acknowledgement of a relationship. And so what I meant, why that was sort of important to me, and why I wanted to sort of end the sort of formal discussion there and open it up to questions, is because in my mind, that was really Lex Mercatoria. The businesses believed that relational contracting was more important than the particular terms, but they still wanted a contract. They still wanted the legal advice. They still wanted us to make sure the language worked, even if it wasn't favorable. And they still wanted to make sure it was enforceable. I mean, at least as an idea, if not in practice, because we would have, essentially, our clients would essentially have no rights. And the reason I wanted to sort of leave it on that point was that for me as a foreign lawyer, trained in the sort of very common law, tight, hard, very draconian way of looking at, the sort of terminology, every word counts. If the clause says this, we'll cut it to, we'll cut our interpretation as finely as we can. To my counterparts in Indonesia, who also, even though they also saw the problems in the contract, but what was going on was there was a series of different relationships and different roles for what the lawyer was there for. And in this instance, what we were doing was an example of sanctification. We weren't there to draft the contract as a tightly formed legal document. We were there to annotate and ascribe a relationship. And the business person never really presumed that that contract would be enforced either by arbitration or by a court. Because business person presumed that the relationship was going to be one of trust, and that they would mediate any problems. And that if there wasn't trust and there wasn't goodwill, it didn't matter what contract there was. And actually, to be sort of fair to this business person, if you used Indonesian courts as an exemplar of contractual enforcement, there's a point that that contract enforcement is less than optimal. And there are critiques of Indonesian contract law. But more important than that, if you look at the work of Kwan Nguyen, who did contract law and relational contracting in Vietnam, it's also worth recognizing that the idea of relational contracting in and of itself is worth respecting as a legal idea, as a series of important private orderings. And I think, and that's the point I'm going to end it at, that if we want to reimagine Lex Mercatoria, that an important element of that reimagination is going to have to be thinking and rethinking about a lot of the presumptions that we take to our legal roles and duties. And on that note, I'll look forward to questions and discussion.